प्रगति, आप अपना थोड़ा सा परिचय बताएं जिससे मार्केट ग्रोथ शुरू किया जा सके।
Okay, sir. Sir, I have completed my graduation, which was BBA LLB honors from Sri Ram Sarup Memorial University, Lucknow, in year 2020. Thereafter, I took admission for LLM, which I completed in year 2022. It was 2-year LLM from Banaras Hindu University, and thereafter, I am preparing for judicial services.
What is the full form of LLM?
Sir, okay, sir. Sir, full form of LLM is the Masters of Law, sir. It is Masters of Law, Masters of Legislative Law.
Masters of Law.
Sir, it is Masters of Legislative Law.
Only legislative law.
Yes.
Someone do their LLM in jurisprudence. Jurisprudence is not legislative law.
Pardon, sir?
Someone do their specialization in LLM in jurisprudence. Jurisprudence is not legislative law.
Yes, sir.
So how you justify your full form Masters of Legislative Law?
Sir, I'll read about it.
And you have said masters.
Yes.
Masters means plural master. Master. It's master of laws.
Okay, sir. Okay, sir. Thank you.
What is your best preparation in procedural law?
Pardon, sir?
What is your best prepared paper in procedural law?
Sir, I like Ibn Evidence Act.
What do you mean by evidence?
Pardon, sir?
What is evidence?
Evidence, sir. Sir, evidence can be defined as, according to the Indian Evidence Act, the interpretation clause or definition clause is provided under Section 3. So, evidence is, it can be either oral evidence or documentary evidence. So, if we talk about oral evidence, then any state...
Oral and documentary evidence is a kind of evidence. What is evidence?
Sir, any statement which is made before the court, which can be made before court, and or any document which is presented before the court for its inspection. So the documentary part will be documentary evidence and the statement part will be oral evidence.
What is the basic principles of evidence?
Sir, there are the basic principle of evidence is firstly that the evidence which is produced must be relevant, must be of relevant fact and fact in issue only. And thereafter, the second principle is that the evidence must be direct; it must not be a hearsay evidence. And sir, sir, these are the two principles of the Evidence Act.
Hearsay evidence must be excluded.
Yes, sir.
There are three basic principles of Indian Evidence Act.
Sir, I can recall these two right now.
What is fact in issue?
Sir, fact in issue is basically any fact which is asserted by one party and denied by the other party, and which is so important for that particular matter that if the right of the parties depend on that particular fact, that would be a fact in issue.
And what is res geste?
Sir, the principle of the res geste is a Latin term. In English, it means things said or done in the course of transaction. If we talk about Indian Evidence Act, then this principle is provided under Section 6 of the Indian Evidence Act, which says that anything which is any fact which is a part of the same transaction will be relevant fact for that particular case.
Any difference between res jecta and same part of transaction?
Yes, sir. Sir, in res geste, all the statements or the act or omission, it must be spontaneous and contemporary. But, sir, under Indian Evidence Act, Section 6 makes it clear that the act and omission can be act and omission must be the statement must be spontaneous, and act and omission can be at any time and place.
What is difference between admission and confession?
Sir, in Indian Evidence Act, the term admission has been defined under Section 17. It says that any statement which draw an inference toward fact in issue or relevant fact, that would be admission. And the crux here is that the admission must be made against the interest of the party who is making, which is provided under Section 21. When we talk about confession, then simply it is the admission of guilt by the accused in any criminal cases. And if we differentiate these two, then it can be said that admission can be given in civil cases as well as criminal cases. But when we talk about confession, it can only be given in criminal cases. Also, sir, when we talk about admission, then admission of co-plaintiff or co-defendant will not be relevant, but the confession of co-accused will be relevant if they are tried together under same trial.
What is retracted confession?
So retracted confession means when a person has once confessed to its crime before the court, and further at later proceeding or later he withdraws that particular confession and denies the confession itself. That will be the retracted confession.
What is public document?
Sir, public document, sir, as provided, it is the provision for the same is given under Section 74. Sir, it can be said that any document which is prepared by a public servant, public official, in performance of a public duty, then that will be a public document.
What is decree?
Sir, decree is defined under Section 2, Clause 2 of the Code of Civil Procedure, and it is an adjudication by the court. It is a formal adjudication by the court in any matter which is presented before it that conclusively determines the right of the parties.
What is adjudication?
Sir, adjudication means determination by the court of the dispute itself, and it must be in a suit. And sir, there must be application of judicial mind by the court.
What is suit?
Sir, suit is the matter in the dispute itself. It can be said that when any matter is brought before the court for its adjudication, for any kind of differences between the parties, then with the presentation of claim, then that will be suit.
What is essential ingredients of suit?
Sir, the essential ingredients of suit that firstly, sir, there has to be two parties, one who is filing the suit and other who is against it or who is defending it. And second, sir, there has to be a cause of action, and sir, it must be presented before the court.
What is necessary party and proper party?
Sir, a necessary party is the party who is essential to the suit itself, and without whom a proper order, an effective order cannot be passed. And sir, the proper party is the one without whom an order can be passed, but they are important. Their presence is important to finally determine the suit.
What is difference between setup and counterclaim?
Sir, the provision for set-off and counterclaim is provided under section, set-off is provided under section 6 of the Code of Civil Procedure, and for the counterclaim, it is provided under section 6A to 6I. And sir, if you talk about set-off, then basically in a suit, when the defendant, although he accepts the claim of the plaintiff, but at the same time, he is saying that plaintiff is also liable to him for certain thing, for a certain sum of money in the same suit, then that will be a set off. And the counter claim is like a cross claim, like when the defendant has a right to file suit against plaintiff also, and in the same suit he's filing it against the plaintiff, that for a certain sum of money. And but the difference between these two is that for the set off, the amount of the claim of the defendant cannot be more than the amount of the claim of plaintiff, which he has to pay to the plaintiff. But in the set off, that claim of defendant, it can be more than the claim of the plaintiff.
Okay, very good.
What is your specialization in LLM?
Sir, it is criminal law.
Criminal law. What is the basic, you have also studied socio-economic offenses in criminal law.
Yes, sir.
What is the reason for the dowry according to you?
Sir, dowry can be considered as a crime which itself evolved in the society, and the basic reason behind the crime like dowry is and although there is a law which prohibits dowry, but the society itself does not see dowry as an offense. Like for example, sir, if a person has committed a murder, or if a person is a thief, then society will treat him or will see him with a person who is of bad character or a bad person. But at the same time, when a person is taking dowry or giving dowry, then that particular person is not an offender in the eye of society. That's why it is prevalent in the society, and people are not mostly against it, and it is acceptable. It is common belief in the society that the parties to the marriage are.
What is your opinion to remove this evil from the society?
Pardon, sir, to remove?
How we can remove this evil from the society?
Sir, firstly, sir, for these kind of evil, law alone is not enough. There has to be a kind of awareness in the society, education. We should make people understand that this is actually an offense, and it should not be acceptable
by education we can remove this evil.
So by education and by sensitization, making people aware of these things, even in the remoter areas. Like in present time, people who are educated, the trend has been
some of your
changing.
batchmates who had selected in PCS, they were not taking dowry. They are educated and they are also selected in PCS. They are, suppose they are selected in civil services. They are not taking dowry.
Yes, sir. It is true that even a person who is educated and who knows that dowry is an offense, even they are taking dowry at this time. It can be said that society has not been developed enough to understand the kind of evil or the kind.
It's my argument. The amount of dowry increase with the post. If post is higher, amount of dowry is so higher. So
Yes, sir.
your claim that by making education, you can remove dowry, how it's possible?
Sir, there are two things. Firstly, that the person who is taking dowry, they should understand that they are themselves a human being and they are not a thing that can be sold with money according to their competence. Other thing is that, sir, one thing which is very important, that the other party, the party who is giving the dowry, they should also understand that they should stop giving. If the person who is giving dowry understands this.
What is the reason? How they give dowry? They taught their
Sir,
daughters they taught their daughters like son, and their daughter is also selected in PCSA or civil services. So after that, they were giving dowry also.
Sir, then this is wrong. Then in that kind of situation, sir, action should be taken against them for increasing these kind of offenses in society. And
In
maybe
LLM,
with time,
in LLM, you have also studied constitutional law.
yes, sir.
Have you aware about the Venkatacharya Commission?
Pardon, sir.
Venkatacharya report of Venkatacharya Commission.
Sorry, sir, I cannot recall
There
it
are
right.
two commissions, Panchi Commission and Venkatacharya Commission.
Sir, I'll read about
And
it,
both
sir.
commissions are in your syllabus.
Sir, I'll read about it, sir. I cannot recall it right now.
You are not studied that commission's report.
Sir, there was one subject of constitution that was compulsory subject, sir. And sir, I think
In
it's
first
been a
semester,
long
you have
time.
studied compulsory paper of
Yes, sir.
constitution, and in
Yes, sir.
constitution, in your syllabus, Venkatacharya Commission and Panchi Commission was also, but you are not aware about that commissions.
Sir, sorry, sir. I think I have read it, but it's been 2 years, sir. I think I'm forgetting it, sir. I'll read about it again.
Tell about the preamble. What is preamble?
Sir, preamble is the part of the constitution, and it somehow it tells the source of the constitution and the right and duties of the constitution and to whom these right and duties are provided, sir.
What is socialism?
Socialism is a principle which is in interest in our constitution because our government is socialist, our country is socialist. That is, it basically means having a welfare government, a government who can take care of its people and who can ensure that the rights that the resources are equally distributed among the people and that their welfare and their well-being is being ensured.
India is purely socialist nation.
Pardon, sir?
Whether India is purely socialist nation.
Sir, India is socialist, but it cannot be said that it is purely socialist because, sir, the kind of socialism that we have adopted in the mixed economy is different from the other countries. And, sir, the government is not controlling everything here. There is concept of privatization and liberalization because in the mixed economy like India, it is needed. So it is not purely socialist. We can say that Gandhian socialism has been adopted in our constitution.
Currently, a term is in trend, gender sensitization. What do you mean by that?
So gender sensitization is basically to make people understand that how all the genders that we have in our society, all of them are equal, and not to be offensive or not to do any act toward targeting toward any particular gender, and make them understand that equality is for everyone. So this is gender
The
sensitization.
Supreme Court has initiated something about the gender sensitization.
Yes, sir. Sorry, sir, I cannot recall the name of the case itself, but for the LGBTQ communities also the concept of gender sensitization, and for the women also, it has been prevailed and it has been ordered by the Supreme Court.
Whether a property may be transferred to the idols under Transfer of Property Act.
Sir, no, sir. Sir, property cannot be transferred to idle under Transfer of Property Act, because sir, the definition of transfer of property makes it clear that it can be from a living person to another living person, and in the explanation it says that living person also includes any corporation or any company incorporated, but it does not mention that.
Idle is also legal person. And
Yes, sir,
it
idle.
has capacity to hold property.
Yes, sir. Yes, sir. Idle is legal person and it has capacity to hold property. But, sir, according to the section 5, the word legal person has not been mentioned, and only corporation and companies are mentioned. It means the Transfer of Property Act exclude idle from its purview.
How property can be transferred himself?
Sir, it can be transferred to himself if a person is individually holds certain property and he also has a company. Then in that case, he can transfer that property in name of company. But someone should, although the company itself is a legal person, but behind that that will there is someone. So in that case, it can be done.
Okay. Very good.
What is basic principle of trust?
Basic principle. Sorry, sir, I cannot recall it right now.
What is difference between trustee and mutwalli?
Pardon, sir?
Trustee and mutwalli. What is difference between mutwalli and trustee?
Mutawalli and trustee. Sir, Mutawalli is basically a concept under the Muslim law. It is for waqf created. Then in this, sir, if a waqf is created, then in that case, the person who is responsible for management of trust is Mutawalli. And sir, the trustee is sir, trustee. The term is used under the Indian Trust Act. It is a general term which is also used for the private trust. So in that case, when the person holds property for benefit of the third person, then that person will be trustee.
The difference between customary right and customary. What is difference between customary right and customary easement?
Sir, if you talk about customary right, then it can be given to a number of people. But if we talk about customary easement, then it is toward a certain person, or person is claiming that I have this particular easement. And for customary rights, or existence of a particular property that is dominant heritage is not necessary. But in the case of easement, the dominant heritage has to be there, on whom the right of easement is conferred. So that is the difference between customary easement and customary right.
You can file a application or suit under section 125 CRPC, and that could rejected your plea. Thereafter, you move where?
Sir, if the application of maintenance is rejected, then against that, sir, revision can be filed.
Where revision lies?
Sir, to High Court. Sir, to High Court and Court of Session both as well.
Session Court.
Sorry, sir.
In which case?
Where revision is lies, Session Court and High Court both are only High Court or only Session Court?
Sir, both court has right under CRPC. High Court and Session Court both has right of revision.
Where you file your 125 petition?
Sir, it can be filed in any court, I think, and after that,
Any
sir,
court,
either
any court has
sir,
power any court has power to decide your application of 125 CRPC.
Sir, in revision, as it is provided under the code that
Under which court you have filed your application of section 125 of CRPC?
Okay, sir. Sir, initially it will be filed in the family court, and then if the court has rejected, then I'm saying that
And
revision can be filed.
family court's decision will be revised by session court.
Yes, sir. It can be filed in session court or
What is goodwill?
goodwill. Sir, in term of a company, sir, goodwill can be said that the
Not company under partnership.
under partnership act. Sir, it is basically the it can be said that a kind of that a right or the reputation that the company has with itself, then that thing can be considered as the goodwill of the company, the name of the company, the reputation itself.
What is implied authority?
The implied authorities are, according to the Partnership Act, is that sir, there are certain acts which are if there are certain acts which partner is authorized to do in the normal course of circumstances in the course of business, then that will be the implied authority of a partner, and for that act of partner, other partner and the firm itself will be liable to a third person.
What is difference between mayor and president?
Pardon, sir?
What is difference between mayor and president?
Mayor. Sorry, sir, I'll read about it, sir. I'm not sure right now.